Hello, everybody. She was waiting. She was absolutely waiting. She knew. She knew what time was coming. You're a good girl. Everybody's favorite baby. Hello, Manny. I just love when you're here. Oh, Mama. Hello, Z-Rex. Earl's being goofy again. Just for you. Hello, Auntie M. Oh, interesting. Oh, Earl's got the butt wiggle. Earl's got the butt wiggle. Here, take this and go. Earl's got the butt wiggle. He's stopped now. Now he's... Gotta love that cat. Hello, Nana Laura. Hello, Jerry Matthew Boyd. Hello, Michelle Moreland, sweetie. Oh, we're happy you're here, love. You are always so special here. That's what we are. Truly. Truly. Well, I mean, I tagged everyone. I do. I love every one of you. Hello, Donald Westerdale, sweetie. Hello, Joey Bag of Donuts. Yes, that fine homemade cough medicine made by the light of the moon that begins with corn mash. Hello, Eileen and Carlin. Hello, Charlie. I love you. Yeah, she's being extra special tonight. She was barking at the window for a good 10 minutes at pretty much nothing. Just being herself. I did get them. Calming chews for cats and for dogs. They didn't really care for them. I mean, Ava will take them sometimes, sort of, but she like chews it real slowly. Not like it's her favorite thing on earth. It's definitely not a Blue Buffalo health bar. But, I mean, she will take it. She's taking it better than she used to, actually. Maybe I just needed to let him sit for a few months. I don't know. But they say helps manage stress, promotes relaxation, helps restless dogs, chicken flavor. I mean, they're supposedly CBD for dogs. We'll see. We'll see. Maybe she'll settle down. She's back to licking her paws again, but I think it's because of the salt. When they salt the ramp, so I think it's drying out her paw pads. So yeah, hi baby, sweetie, you've got your 3 treats. You just got extra treats. There's no treats up here. You're not getting cat treats. I'm sorry. Hello, Blackstyle. Well, of course. Of course we would be. I think we all understand each other better than the rest of the world understands us. All of us have medical issues that we've had to fight for years to get diagnoses on, or to get any kind of visibility from the medical community. A lot of us have been, shot in the foot by our own doctors, or, left by the wayside. So we all understand the pain that we've all gone through together. And it binds us and bonds us. Hello, Patrick P. You are so beautiful. Hello, Kendall Smith. Yeah, she's the best. I had a healthcare professional worker here today doing another one of those charming assessments. And so that blocked off my afternoon. But yeah, I was explaining the channel to her, and because she asked me if I ever thought of therapy, and I'm like, well, I have been told that that my chat community is therapy for all of us. Hello, Mortimer Duke. Drive safe, sweetie. I got shot in the thigh by a BB gun by one of my brothers. Yeah, that was fantastic. Earl's got the zoomies currently. If you can't hear him. Earl! That's Earl in there. Oh, I kind of need the services, so I have to. She was actually really great. She sat and talked, and like, oh my gosh. We talked more about like life, and you know, I explained the accident, and I talked about my daughter, and yeah, it was a very casual appointment. Now my favorite is, does it hurt where does it hurt when I poke here? Poke, yes. Ow. Oh, okay. Well, does it hurt worse when I poke harder? You sadistic, get away from me. Oh man. Oh, the stories of the my family. We should have been issued one spork each at birth, and that was it. Like that should have been it for utensils. Let's see, my mom cut my dad's earlobe off. Or no. My brother's earlobe off when cutting his hair. She also cut my brother's lip, or my dad's lip. Okay, let me start this over. My mom cut my brother's earlobe off when cutting his hair. She was giving it a little trim for his, 6 foot long mullet. My mom cut my dad's lip when trimming his mustache. My brother Jesse stabbed my father in the belly with a knife. Yeah. Oh my. Like, my brother Martin, he liked to just stab things too. Never intentional. Never. It was never an intentional bloodbath, but it was always a bloodbath. Ooh, Auntie M, you've hit 2 years. Thank you so much. It would have been if I hadn't screwed it up 4 times. It wasn't a ritual, it was a tradition. Yeah. When they say a little off the top, they don't mean of the skin. And my dad shouldn't have talked. I'm gonna leave that alone. Oh my gosh. Yeah, so anyways, fun times, fun times. So I got voluntold today that I'm having a mommy daughter day tomorrow. My daughter needs a ride to the big city, La Crosse, and so of course I am transportation, which means I have to get my wheelchair loaded up tomorrow. Come on. I know there's some in here. My hands are so dry. Dang winter. So yeah, I gotta get my wheelchair put into the van tomorrow. So I do have some cases. We'll have to see how far we get on everything. You know, they say if you put a vibrator on it, it'll come out. Let's see if it works. Oh, dag nabbit. It's dead. I never use this one. What kind of batteries does it take? AAA's. Ooh, I got those. Everybody, I'll be right back. Science! Science! And I really want my lotion. Now I have cat fur all over my desk because that thing was never used. I don't know how it died. It's so unused that it's covered in cat fur, like everything else. I swear, every meal that I eat has cat fur garnish. All right, let's go this one this way, this one this way. Apparently they're backwards. This one this way, this one this way. No, it's just broken. Well, that's disappointing. I don't feel like I got my $4.88 worth. Do they go the same way, maybe? No, that wouldn't complete the circuit. Clearly not. Try it this way. Nope. Dag nabbit. Well, I know the batteries are good. That sucks. Oh, I felt a little. That's got to be the right way, but why is this not working? I felt it had a little zzz, and then it quit. Just because I want it to work. Oh, there it is. There it goes. There. Oh, I just got to hold the battery compartment thingy in. There. Okay, now. Come on. Keep going. Okay, supposedly this makes it come out. We'll see. It shouldn't. Let's see. Come on. How long do I wait? Oh, it does. Like, it appears like it's working. This thing's just got no power to it. I think that's like the 99% of the problem is there's really no oomph to it. Ugh. Okay, guys. I'm going to put cases on and then fart with this. Hey now, I got it working. It's not my fault that it's broken. I have to push the release button. Oh, Well, that can't help. A piece just literally broke off. Oh, now it works. Now that piece broke off. It's still very faint though. But I don't want to be tapping in your guys' ears, so I am going to I'm gonna put some fun stuff on. Let's see here.
Okay.
I'm sorry. Good afternoon, Your Honor. Rebecca Kelly on behalf of the people.
Okay. Good afternoon. I'm not ready yet.
Okay.
Deputy, can we get Mr. Bazile? Are you Dimitri or Devon?
Dimitri.
All right. Is the deputy still there?
No, he's not. He walked away for a second.
See if we can get his attention, because this just makes sense doing them both at the same time.
Yeah.
This is your client, right, Mr. Sabot?
Yes, Judge, it's my client.
I don't know why the judge put both on.
Mr. Stablin represents the Devon.
Good afternoon, Your Honor.
Good afternoon. I'm trying to get them both on at the same time. Text report officer.
I think they was counting to get.
They'll bring them on in about 2 minutes. Then we can just set a date without them. I mean, both waive 21 days. So
I just got you on my list. So.
that.
Yes, sir.
Judge Bowie.
Yes, sir.
Can I have Devon Bazile as well? They are co-defendants on the same case,
Hold on, Your Honor. Let me see.
and they're both supposed to be on at 1:45.
Hold on. Yeah, he should be on, Your Honor.
Or he's not on.
Hold on. Let me double check.
John. Barry, Robert, George, Linda. The jailers all just start calling each other's names. What the hell?
Your Honor, he's coming. Oh, okay. How you doing? Good. Y'all look like. Your brother should be on short with the pull-ups right now. Okay.
All right. Case number 251577 FY, People State of Michigan versus Devon Bazile, charged to count 1, controlled substance, delivery, manufacturer, cocaine, heroin, or another narcotics, 450 to 999 grams. Count 2, felony firearms. Count 3, same count as count 1. Count 4, felony firearms. Count 5, controlled substance, delivery, manufacturer, ecstasy. Count 6, felony firearms. Count 7, possession by a prohibited person of a firearm. And count 8, felony firearms. The 251578 FY, People State of Michigan versus Dimitri Bazile. He's charged in the 2 defendant complaint with count 1, controlled substance, delivery, manufacturing, cocaine, heroin, or another narcotic, 450 to 999 grams. Count 2, felony firearms. Count 3, controlled substance, delivery, manufacturing, 50 to 449 grams. Count 4, felony firearms. Count 5, delivery, manufacture of methamphetamine or ecstasy, and count 6, felony firearms. Appearance of the record.
Good afternoon, Your Honor. Rebecca Kelly on behalf of the people.
Jerome Sabota on behalf of Dimitri Bazile.
And good afternoon, Your Honor. Paul Stablin appearing on behalf of Devon Bazile.
Mr. Dimitri Bazil, state your name.
Dimitri Brazil.
Sounds good, but it's not.
Devon Bazil, please state your name.
Devon Brazil.
Okay, we're here for probable cause. Second, probable cause, how are we proceeding?
I'd ask that the matter be sent for preliminary examination.
Same, Judge.
All right, it'll be a Friday exam. Do have notes from Judge Walker saying possibly 5 to 6 witnesses. Is that correct?
Approximately, yes.
Correct the record, Mr. Bazil, Devin Bazil is charged in count 3 with controlled substance delivery manufacturing of 50 to 449 grams. I believe I said it's the same as count 1, but no, it's 50 to 449 grams.
Okay, thank you.
Maybe the 6th,
All right, let's see here.
the 13th, no, you can do the 6th of February, but it'll be at 2 o'clock. Or we can do the 20th, or we could do the 20th at 9.
I would prefer the 20th, Your Honor, if we could.
I have a
I'm
trial
out-
that's going to be, I have a trial going on the 6th. Or the,
I'm out of town on the 6th, Judge. The 20th is fine.
20th works.
Or I could do January 30th.
I may be out of town on the 30th too.
We'll do
I'm
the
available
20th.
on that date, but if we can go the 20th in February, that would be great. Thank you.
Does that work for you, Mr. Stadler? I know you probably had some reservation.
No, the 20th is fine.
Okay. We'll do it at 9 o'clock in the morning in person.
Thank you very much, Your Honor.
Judge, can I
Yes.
ask that the prosecutor furnish us their surveillance notes from 341 First Avenue?
Generally, Your Honor, I've had most experiences where the officers are not keeping surveillance notes. So I will check, but more than likely there are none.
Okay.
All right, can you check for that, Miss Kelly, please?
I will.
All right.
Thank you.
Judge, one
Yes.
thing I want, we addressed this last week, but I wanted to address the court in regard to bond. Devon Bazile is being held on a $500,000 bond, which I understand the charges are serious, but the fact is that that's an extraordinary bond under the circumstances, Judge.
Sir, did you hear what your client was charged with? The manufacturing, sale, and delivery of some pretty toxic stuff there. $500,000 sounds pretty reasonable to me. I mean, don't take my opinion for it though.
And he has there's nothing, I mean, he doesn't have any history of not appearing in court when he has cases. And because he did have another case that was pending at the time that this one was charged. But I would ask the court to consider a more reasonable bond under the circumstances. And there's no reason to think that Mr. Bazile is going to flee. There's nothing. His ties are all in city of Pontiac here in Michigan. And he, at the time that the search warrant was executed here at this one address, he wasn't even there. He was staying in West Bloomfield with his girlfriend. And just as it relates to the facts of the case, Judge, I understand the charges are serious. He's presumed innocent at this point, and I would ask the court to consider a more reasonable bond. And if the court feels that there has to be some kind of bond, I would ask the court to consider something in the range of 50,000, 10%.
Mighty Methany wouldn't have a bond because she don't get caught.
Your Honor, just if I may respond.
Right.
Okay. Your Honor, I believe one of the reasons why the bond is so high is that actually for both of the defendants, they have trafficking and drug convictions out of state. Devon specifically has possession of drugs, RNC of stolen possession and tools, burglary tools out of Ohio.
Oh, yes, Joey Bag of Donuts. He's one of yours, too.
He has a trafficking drug and aggravated trafficking drugs and RNC of additional stolen property out of, again, Ohio, Bowling Green from 2017 and then 2020. And then in addition, he had a home invasion, 2 home invasions and a DV in 2019 and another DV out of 2018. So I believe that the concern is not only that he, he does have ties out of state, and I'm sure Mr. Sabota will want to address the other Bazile, but I do believe that given the high amount of alcohol, or pardon me, high amount of controlled substances, and the obvious ties that he has out of state, not just one incident, but multiple incidents, I believe that the bond is appropriate.
See, he was in Ohio, and then Joey Bag of Donuts gave him the little pss, pss, and made him move to Michigan.
Can I respond to that, Judge? Because the court has available to it other methods or conditions of bond that the court could impose, like a tether to monitor Mr. Bazile's whereabouts. If the court is concerned about anything that the prosecution just said, we can take care of that by having a tether or even having him on a curfew at his home or even house arrest if the court considers it. But it's very difficult for any defense attorney to try to adequately defend a case when an individual is incarcerated. Makes it very difficult to communicate and to try to prepare for this case.
Your Honor, I might agree with the tether if that was just simply the domestic violence and he only had connections to within Michigan. But given the fact that he does have out-of-state connections, I don't believe that there was any abuse of discretion when the original bond was set. And obviously, Mr. Stavlin has been an attorney for quite some time, and I know that he knows how to work with various different communication tools that the OCJ allows for. So,
yeah, speaking of tools, it's not like any defendant has ever cut off a tether before. No, it's never happened.
I would object.
I'll be honest with you, all of this is nice, but I'm stuck on the fact that he has a pending case before me, when the exam already set for February 24th, 2026. So with everybody, when I saw that, I just didn't hear any other arguments, respectfully, because that's a delivery case.
Correct.
So let's talk about this. Ohio drug trafficking case in 2017, 304 to 730 days in Ohio prison. And in August 2018, he got a guilty for 1 domestic violence. December 18, guilty for a 2nd domestic violence against the same woman. To my mind, so it baffles me how I don't understand. And help me, Miss Kelly. When I was a prosecutor, I had the criminal background, and I know how many domestic violence someone's had. Both of these cases were in the state of Michigan, and there was a guilty on a domestic violence 2nd after he's already been found guilty of domestic violence 2nd. So it should have been DV3. I don't know if it was played down, but I have come across in my court complaints where charges were filed and the person had at least 3 or 4 prior domestic violences and they're still misdemeanors. That's a big problem.
I would agree.
So he has a domestic violence 3rd against the same woman, Ariana Teasley. And then, so I hear all the arguments, Mr. Stable, you're a fine attorney. So I hear that, but I became blind and deaf when I saw that he has a delivery manufacturing pending before me with an exam already set in February. So he
never failed to appear,
case.
Judge.
Huh?
He never failed to appear when he was directed by this court.
But we got a bigger case while he was on pretrial release to me in that case. So quite frankly, the magistrate was very reasonable. I don't know if she had that information. She probably did. So I think the bond is reasonable. Actually, she gave you a cash surety.
Is he done?
So Mr. Bazile, I'm going to leave the bond. Devin Bazile, I'm going to leave the bond as is. I mean, he got that case in front of me, and then he got this one. I mean, I'm not.
He is presumed innocent, Judge. You're assuming that
No, he is
facts
presumed
of this case are
innocent,
going to.
and I do understand that, but I have to look at, obviously a part of the bond factors is his history. Part of the bond factor is dangerous community. Dangerous community don't mean just shooting a gun and stabbing people. It could be delivering, manufacturing drugs. That's a part of it, And so, but I think the most thing that upsets me is the fact that we got a bigger case and he was already out on pretrial release to me. That's 100% the thing that is making me upset.
And I don't want to get the court upset, of course, but would the court consider then a 10% provision? I don't know that Mr. Bazil would ever be able to make a bond like that, but at least it seems more thoughtful as opposed to just saying $500,000.
I think it's reasonable, Mr. Stabman. I think you made a great effort, but no, when I saw that just took the cake for me. Like, I mean, I think it's just disrespectful. You're out on pretrial release already, and you're showing me that you're going to pick up another case. Now, if he's guilty, I don't know. That's not my job here, and I'm not basing my decision off that. But you got a drug case when the exam set already in February. Now you got another drug case when the exam that we just set in February. If it walks like a duck, quacks like a duck, it looks like a duck, then it might be a duck. So he's all set.
All right.
Mr. Dimitri.
Your Honor, Jerome Sabota again on behalf of Dimitri Bazil. Ms. Kelly's correct. I was going to ask for a bond. I asked for it at the PCC. He does not have a substantial criminal record, to my understanding. He has nothing. If you note, when you look at the charges themselves, though he's charged with felony firearm, he's not charged with being a felon in possession of a weapon, which they generally do, and they did it in relation to Devon. Because he has a prior felony record, there's no evidence that he's ever not appeared. He's been in the system, but he does not have a felony record. He doesn't have anything pending. There is no, and he's got substantial ties to the community, including the house he was living in. So he's also hired counsel. And I would echo some of the statements that Mr. Stablin made, that it's obviously easier for both him and I, if he's out on bond, for me to communicate with him. Now, you can form conditions which can assure his appearance, even though he's always appeared. You can place him on tether, you can put him on a curfew. But the bond that they set, my understanding, it's $250,000 cash surety, and that's a bond he's not going to be able to make. Most people could never make that bond. That's in effect no bond. And there is a presumption of innocence, and I'm asking for a $50,000 10% bond for all of the charges.
Your Honor, just in response, we because of the holidays, I have not been able to confirm, but it does appear that he does have what appears to be 3 priors, 2 misdemeanor possession of marijuana with varying degrees out of Texas, and then also a 5-pound marijuana possession, which is a felony. And I don't know what the status of that is, and we are trying to confirm that, because then, of course, if it is a felony, then we will be charging and amending him to a felon in possession. So given my concern is, once again, this defendant has ties out of state, specifically with Texas, which is even further away. So I do have concerns about his being, having those ties out of state. So
clearly the the prosecuting attorney is mistaken. The defendant said that he had no other charges. The lawyers said my clients told me that he doesn't have any charges. No, the prosecuting attorney is just mistaken all around here. She doesn't have any kind of proof or records from these other states. No.
There's quite a large amount of methamphetamine and narcotics in this case, along with guns. And so I do believe that once again, this is half the bond that his co-defendant has. And I don't think that it's unreasonable. I don't think that there was any lack of discretion on behalf of the magistrate who set the bond.
Your Honor, are you done, Ms. Kelly?
I am, thank you.
Your Honor, because they think he has a criminal record, which is a felony, really shouldn't be taken into consideration. Either has the felony conviction or he doesn't. And this case stems from charges issued on December the 19th, which is almost 2.5 weeks ago. They should be able to find out whether he has a felony record or not. He advises me he does not have a felony record. And that's
All
an
right,
older
so
case. So there's no reason to hold that against him at this juncture. So I'm asking the court for the $50,000 10% bond.
And though he may not have a felony, Your Honor, he does have the 2 misdemeanors from Texas.
How old are they? They're like 10,
Let's-
almost.
I think
22. I'm sorry, 20 and from 2022.
I have one 18. There's one in. The only ones I see is April of 18. He has allowing out of 44, and then one was dismissed out of Polk County. So, but I'll give him 250, 10% cash surety.
Thank you. And the other,
He'll be on house arrest except for court and medical appointments, and then both are not to have contact with each other.
except for court medical appointments and in order for him to see his counsel.
That's fine. Well, that's fine. But we got Zoom, Mr. Samoa. But
Okay. The other thing is I want to remind the prosecutor, we're still lacking the body cameras.
Those should
Right.
have been sent. Like I said, I will check again because I talked
Okay.
to you last week about that.
Yeah, I'm not saying you did anything wrong. I'm just saying I haven't received them.
Okay.
all right, so we're all set. So to recap, Mr. Doin Brazil bond is continued. I will note that we need audio and video disco, and that also no contact with the co-defendant. And then Mr. Dimitri Brazil bond has been amended 250,000 cash surety 10%. I will note that Mr. Sabota needs the audio video disco, in that Mr. Dimitri is not to have any contact with Devon and vice versa. So we're all set. Our exam is February 20th at 9 a.m. I'm sitting here thinking, should I move Mr. Brazil's other exam to that same day? But I don't know who the prosecutor's on that. So
It
I
is-
don't represent him on that either, Judge.
It will be me, but it is a different defense attorney.
who was that defense attorney? I would rather have him for both days.
I think it's Mr. McGill. I'm sorry, I'm looking through.
I think it's someone named Sheena.
Sheena,
Okay.
that's right.
Okay, if it changes, we'll reach out. Well, we'll reach out to Sheena. If he's okay with it being on the 20th, then we'll move it to the 20th, probably at 11 o'clock.
Okay, thank you very much, Your Honor.
We'll let you know. Okay,
I
Thank
appreciate
you.
it.
Thank
Thank
you.
no problem.
Thank you, Your Honor.
All right, take care, everyone. Thank you.
You
Thank
too.
you, Hon.
Mm.
Who? Yes, okay. Come to the podium, Miss Brown. Come to the podium. All right, Miss Kennedy, Miss Brown just walked in. We're ready. I don't know where Miss Kamaj went. Just give me 1 second.
Thank you, Your Honor.
Yes.
You're all gonna thank me. You're all gonna be so grateful for that zoomed image.
This is Mrs. Brown, Miss Kamaj. It's number 251363, FY People State of Michigan versus Carla Denise Brown. She's charged with count 1, controlled substance, possession of cocaine, heroin, or another narcotic less than 25 grams. Count 2, operating with no license on person. Count 3, operating an unregistered vehicle. Appearance to the record.
Good afternoon, Your Honor. Laura Flash from the Ethical People.
Good afternoon, Your Honor. Robin Kennedy appearing on behalf of Ms. Brown, who is present in the courtroom. And my apologies, Your Honor. If I had known she was planning to be in person, I would have been in person myself.
Well, no worries. Ms. Brown, good afternoon. Please state your name for the record.
Miss Brown.
Okay, we're here for a probable cause conference. How we proceeding? How are we proceeding today?
Your Honor, I did reach out to Ms. Kamaj to inquire as to whether there would be any offers to resolve the matter in the district court. I know that was just within the last couple of hours, so I don't know if she's had the opportunity to review that. So I would leave that to Ms. Kamaj at this point.
If you sent that email to me the last couple hours, I would not have had a chance to review it now.
Your Honor, then if since that's the case, then I would just ask for one last very brief adjournment because I did discuss the matter with Ms. Brown. And if there is a possibility that we're able to resolve it in district court, then we certainly would like to do that. So I just would want to give Ms. Kamaj the opportunity to review my correspondence.
And then it's showing that she has not been tested. I got a report that's dated the 30th saying as of the 28th, well, as of the 30th, the date of this report, she is not tested. So she's going to test today. So she's going to go downstairs and talk to probation so they can,
Okay.
so she can get a test today. And she's going to continue testing or is she going to be in jail?
Absolutely. You understand that, Ms. Brown?
It was my brother, it was my cousin. When I went up there, I did everything said that. I called them everything. Every time I got there, they were let me in.
Okay, we'll go down to probation and figure out how you can test today. Okay, so let me give you a new date before. So you can come back on the 27th at 1:30. Does that work for you, Ms. Kennedy? That gives
Yes,
Ms.
it does.
That gives Ms. Kamaj about 3 weeks to talk to somebody.
Absolutely.
Okay.
Thank you, Your
All right.
Honor.
We'll continue the bond. She's all set.
Thank you.
Thank you. 27th at 1:30. She will test that.
I tried to enhance that, but the judge said, I don't think she's gonna, what did he say? Hold on. Let me go back 2 seconds here.
We'll continue the bond. She's all set.
Thank you.
Thank you. 27th at 1:30. She will test that.
I don't think she will test negative. That's what he said. Yeah. Oh my gosh. She was so tweaking. But it wasn't my fault. It wasn't my fault, Judge. Every time I went there, they locked the door. Well, I can't imagine why. Oh, it was not her hair. You could tell the reason she kept going like this, it was a wig and she was adjusting it. Yeah. No, it was not her real hair. Hello, Jenny Green. Oh my gosh. Yeah. He knew it too. He knew it. That's that's why he started looking at her testing history. Yeah, I don't think she's gonna test negative. Or she's not gonna test negative. Yeah. Oh, I'm sure it's coming. We'll see that soon. A glue-on? They have those? Glued-on wigs? Like, I've not heard of that. I've heard of, like, where they've got these little barrettes that you snap in all over. And I've heard of ones that literally get sewn onto your head. I've not heard of glued on though. But I can't keep up with all that fancy shenanigan stuff. Maybe. I've worn a wig like twice in my life. And it was because my my ex's mother was obsessed with them, and she wanted me to have, much more beautiful, lovely hair with this hideous straight hairline kind of thing that I hated it. I hated it. And it was so hot and sweaty. No, not my thing. Not my thing. No, see, I had no idea. That, that could explain a few things. Oh, yeah, she's going to say she didn't understand. She, what are you doing? Oh, guys, Earl is on something. All right, I've got another set of cases. I had to do it in 2 batches today.
I'll give you a couple of moments to reach out to him, but I intend to proceed forward on this case relatively quickly. The reason being, not only has Mr. Laurie failed to appear on one occasion, I've also adjourned on a different occasion to give him more time to have these cases potentially catch up. However, I'll take a break and let you try to get into contact with him, and then we'll be ready to proceed. So the court will take a brief recess, and I intend to call this matter in about 5 minutes or when I see him. Thank you, Your Honor. Court recalls the matters of People versus Jericho Hawk Lori, file 25-6883 and 6936FH. Counsel, if you could start with your appearances again, please.
Aaron Fortier on behalf of the people.
James Dick on behalf of Mr. Laurie.
Thank you, sir. Are you Jericho Hawk Lori?
I am.
Mr. Laurie, this is the last time that I'm going to call your matter other than the time that is scheduled at. If I attempt to call your matter and you're not present, the result is going to be a bench warrant. And the result of the bench warrant is you're going to be sitting in the Otsego County Jail until this matter is resolved. Do you understand?
Yes, sir. I do. That is my apologies, sir. I thought my court was 9:15 on my apologies.
That's all right, Mr. Laurie, as long as you understand that this is a one-time deal for you being late again. And I say that because I'm aware of the background of this case where you have 2 felony files and you've already failed to appear in court once. So I'm not going to tolerate it again, even though I made an exception today. Mr. Laurie, when I first called the case, I asked your attorney if he'd had contact with you. He suggested that he had talked to you yesterday. Can I be confident that you feel you've had enough time to talk with Mr. Dick prior to today?
I believe so. Yes, we've spoke plenty. I'm very confident.
All right, then Mr. Dick, on behalf of Mr. Laurie, how do you think the court should be proceeding in each of these matters?
Your Honor, we have a resolution to both matters today.
Okay. And the terms of those resolutions?
Your Honor, in file number 25-6883-FH, Mr. Laurie will be pleading guilty to count 2 as a habitual third and to count 3 the OWI in exchange for dismissal of the original, of count 1. And in case number 25-6936-FH, Mr. Laurie will be pleading guilty to an added count 2 of breaking and entering without owner's permission. That is in exchange for a dismissal of the original charge, Your Honor.
And the maximum penalty and maximum fine for the B&E without permission, is that a 93-day?
90 days, 100.
Is that accurate, Mr. Fortier, as to all of those things?
It's so that one, Your Honor, the breaking and entering illegal entry is a 90-day misdemeanor and or a $500 fine. And that is MCL 750.115 sub 1.
All right, Mr. Dick, do you agree with that maximum fine and maximum penalty for the B&E without permission?
The maximum penalty, yes, I may have made a mistake as to the maximum fine on that, Your
Honor. All right, in any event, you don't dispute that the maximum fine is $500.
I actually just pulled up the statute. It actually, oh no, I do not.
Okay. Mr. Laurie, were you able to hear all of that?
I believe so, and if not, I at least the B&E stuff I heard for sure.
Well, I'll go through all of it with you, but have you had time to talk with your attorney about the plea offer?
Yes, I mean yes, absolutely, I have.
And do you understand the terms of the plea offer?
I believe I do.
We'll make sure that you do, Mr. Laurie, but the better question is this: did you want to go forward with the plea agreement after I go through it in detail with you today?
Yes, Your Honor, I would.
Raise your right hand, please. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
So, Mr. Laurie, you have two different files involved. The first file is file 6883. In that case, you're charged with drug offenses and an operating while intoxicated offense. In that file, you're going to be pleading guilty first to count 2, which is controlled substance possession of analogs. And you're going to be pleading guilty as a habitual offender, third offense notice for that offense. Do you understand that?
I do.
Controlled substance possession of analogs as a habitual offender, third offense notice is punishable by up to 4 years in the state prison system and or a fine of up to $4,000. Are you aware of that?
I am, Your Honor.
You're also going to be pleading guilty in that file to the offense known as operating while intoxicated. Operating while intoxicated is a misdemeanor offense, and the maximum punishment for that offense is 93 days in jail and or a fine of $100 minimum up to $500 maximum. And the court can order up to 360 hours of community service. Are you aware of that?
I am now.
The court can also order rehabilitative programs, and there is vehicle immobilization, which is mandatory if you had a prior operating while intoxicated offense. The court can order you to pay the cost of prosecution and to reimburse the government for emergency response. Do you understand all of those items?
Do.
The understanding that I have and that the prosecutor and your attorney have made me aware of is that if you plead guilty to count 2 as a habitual third in the operating while intoxicated offense in that first file, then the prosecutor would dismiss the other charge, the possession of cocaine, heroin, or another narcotic, as well as a second or subsequent offense notice or double penalty possibility in each of the drug charges. Are you aware of that benefit of the plea agreement?
Okay.
Is that a yes?
Yes. Yeah, I'm sorry. Can you repeat that? I'm sorry. Can you repeat that? I guess.
Are you aware of the benefit of having those other charges and other enhancements dismissed in that first file?
Absolutely, yes.
In the second file, you're going to be pleading guilty to what's called an added count 2. That's an offense that you were not charged with, that the prosecutor and your attorney are adding for purposes of a plea. That added count 2 is known as breaking and entering without the owner's permission. That is a misdemeanor offense, and the maximum punishment is up to 90 days in jail and or a maximum $500 fine. Do you understand those maximum penalties?
I do.
And the benefit in that other file is that if you plead guilty to that misdemeanor, breaking and entering without owner's permission, the prosecutor dismissed the larceny in a building and the habitual third offense notice charge that he had filed against you. Do you understand the benefits of the plea agreement?
I understand the benefits of it. I understand the benefits of it.
Understanding both the benefits of the plea agreement and having certain matters dismissed, and understanding the maximum penalty for the offenses to which you will be entering a guilty plea, what is your plea to count 2 in the offense of controlled substance possession of analogs?
Guilty.
You acknowledge being a habitual offender, third offense notice for that offense?
If I have to.
You do have to if you want to take advantage of the plea offer.
Okay, then yes, Your Honor.
Do you acknowledge, and how do you plead then to the operating while intoxicated charge?
Guilty as well.
And then how do you plead to count 2 in the other file, breaking and entering without owner's permission?
Guilty.
If you plead guilty across each of these files, you no longer have any automatic right to appeal. Instead, your appeal rights become more limited. You would have to ask the Court of Appeals for what's called leave to appeal. Do you understand that?
I do.
If you plead guilty, you give up all of your current trial rights in each of these files. Those trial rights include the right to be tried by a jury of your peers, the right to be presumed innocent until you're proven guilty, and the right to have the prosecutor bear the burden of proving your guilt beyond a reasonable doubt. At your trials, you'd have a right to have the witnesses against you to appear, be ordered to appear, and you'd have the right to see, hear, and question them. You'd also have the right to have the court order any witnesses on your behalf be ordered to appear at trial. You'd have a right to remain silent and not have that silence used against you, and you'd have the right to testify at trial if you wanted to. But if you plead guilty, you lose those trial rights. Do you understand? And also, because you're giving up your right to trial itself, you necessarily also give up the right to challenge other things that you might have been able to challenge if you did have a trial. Do you understand that?
So understand that.
You say you do understand that?
I do. Yes.
I'm just trying to make clear, Mr. Laurie, because our audio connection is not the greatest. So if I repeat myself, that's the reason, is I'm just trying to make sure we have a clear record. Mr. Laurie,
Yeah,
outside of the plea that we've gone over on the record, has anyone promised you anything else to get you to plead guilty?
Oh, Your Honor.
Has anyone threatened you in any way to make you feel like you have to plead guilty?
No, Your Honor.
Did you have to think about that question specifically?
I guess I just feel some way, in some way, bullied into some of these charges, but it's my choice. I chose to.
Were you bullied into the crimes you committed, sir? I don't think so.
Say
Let's
again.
flesh that out, Mr. Laurie. You feel bullied because you're charged with offenses?
No, it's I don't want this taken the wrong way, so no, it's fine. No.
The question I asked is a required question in any plea under Michigan law. And the question is straightforward, and that's why I'm somewhat confused by your reaction to it. The question is whether, in the context of this plea agreement, did anyone promise you anything to get you to plead guilty, or did anyone threaten you to make you feel like you have to plead guilty? I have to ask those questions, and then I have to hear a certain answer if you want to accept the plea agreement. So I'm going to start the questions again. Has anyone promised you anything to get you to plead guilty?
No, Your Honor.
Has anyone threatened you in any way to make you feel like you have to plead guilty?
No, Your Honor.
Are you pleading guilty freely and voluntarily?
Absolutely.
Is it your choice to plead guilty?
So it was my choice.
You need to understand, Mr. Laurie, that if I make the determination that you were on parole when you committed a felony offense, then the law requires that I institute consecutive sentencing. Are you aware of that?
If I was on parole, you said?
Correct.
Okay, I'm aware of that now. I was not on. I'm okay.
Now that you're aware of it, did you want to go forward with the plea?
I believe so.
Did you need a moment to think about that?
Yeah, I guess I'm confused because I'm not on parole. I've never been on parole, so I guess I don't understand the significance of I guess.
The significance is this, Mr. Laurie. If the court makes a determination that you were on parole when you commit a new felony, then the court has mandated responsibilities. And that mandated responsibility is, if I made the determination that you were on parole when you commit a new felony, then I have to institute and engage in consecutive sentencing. If I make a determination that you are not on parole, that wouldn't apply to you. But if I make that determination,
I understand.
Consecutive sentencing. If I determine that you commit a felony while you're on felony bond for another offense, then I would have the decision or the discretion to consider consecutive sentencing. Do you understand that?
I do.
Do you understand what consecutive sentencing would mean if it were ordered?
Yes.
Consecutive sentencing, to be clear, would mean that you would entirely serve one sentence before you started serving the next one. Do you understand?
Yep, I do. Yes, I do, Your Honor.
Turning to the offenses themselves, then, the prosecutor claims that what I'll call the drug offense, the possession of analogs, occurred on or about July 30th of 2025 here in Otsego County. So were you present in Otsego County on July 30th of 2025?
Yes.
And on that date, did you knowingly or intentionally possess the controlled substance diazepam?
Yes.
And you did not have a legal authority or a prescription to possess that substance, is that right?
Not current, no.
You did not have a current ability to legally possess it, is that right?
Correct.
At the time that you possessed that controlled substance, had you been twice convicted of felony offenses in the state of Michigan or otherwise prior to that? Was one of those felony convictions a offense of controlled substance possession of analogs in 2012 here in Otsego County?
2012. Yeah, when I was a kid, yeah, it would have been, yes.
So, and then was a second felony conviction in 2020, controlled substance possession of methamphetamine?
Yes, sir.
How old are you right now?
I'm 31.
So in 2012, you would have been 18, is that right?
I was 17, Your Honor.
So you were convicted as an adult of that felony offense, correct?
Correct.
Is it true also that you operated a motor vehicle on July 30th, 2025 within Otsego County?
I did.
While you were operating the motor vehicle, were you under the influence of a controlled substance?
I was.
I'm sorry?
I was.
Turning to the other offense on August 4th of 2025 with respect to the B and E charge, is it true that you entered into a home or a dwelling house of another person without permission?
Incorrect. It was
Sorry.
not a home. It was not a house or a home.
Was it a shop or garage?
Yes, Your Honor.
And did you enter it without permission?
That day I did, Your Honor.
And when you entered it that day without permission, what was your intent?
To borrow tools that I have already had permission to use and borrow.
Mr. Dick, did you want to ask clarifying questions for that latter offense?
Mr. Laurie, on the day at hand, did you have permission that day to use tools from that building or from that property?
No, Your Honor, no, sir, not that day.
Do you believe there's an adequate factual basis for all offenses and the habitual notice, Mr. Fortier?
I do, Your Honor.
Do you agree, Mr. Dick?
Yes, Your Honor.
Do the attorneys believe the court has complied with the court rule regarding the taking of pleas?
Yes, Your Honor.
Yes, it has, Your Honor.
And are either one of the attorneys aware of any promises, threats, or inducements not disclosed on the record?
No, Your Honor.
None, Your Honor.
Mr. Laurie, I find that your pleas have been knowingly, voluntarily executed. I find there's a clear factual basis to support a finding of your guilt as each one of those three offenses and the habitual offender third offense notice. So I accept your plea and enter it on your record. Accept your pleas, rather, and enter them on your record. The next step is I'm going to have you provide your telephone number on the record, and that's so that agents of the Department of Corrections can reach out to you to interview you. The interview will then result in what's called a pre-sentence investigative report, and I'll get a copy of that, so will you, before the sentencing hearing. So go ahead with your phone number.
5523.
Thank you. So make sure and answer the call when you get that from the department. It's your responsibility to meet with them so that PSI can be prepared. Once it's prepared, I'll have you back in front of me. You'll get a separate notice in the mail for a sentencing hearing. That's sorry, ladies. You only get the last 4 digits of his phone number. I know you guys are all so heartbroken, but I had to do it. Sentencing hearing will be in person. So that means you'll be here in the courtroom, so will your attorney, so will the prosecutor. So do you have any questions about any of that?
I do not believe so.
Mr. Fortier, anything further?
No, Your Honor. Thank you.
Mr. Dick, anything further?
Nothing, Your Honor.
All right. Thank you, Mr. Laurie. You're all set today.
Thank you, Your Honor.
All right, the court is bringing in next Mr. Walker and the Assistant Attorney General. All right, welcome, counsel. And I just brought in Levi Walker. Mr. Walker, can you unmute yourself and announce your name for the record, please? All right, welcome, Mr. Walker. We're on the record in the matter of People versus Levi James Walker. This is about 25-6937FH. If you could start with your appearance, counsel, please.
Christina Beta on behalf of the Attorney General, P number 74583.
Thank you and welcome. Mr. Walker, can you state your name for the record, please?
It's Walker.
Thank you, Mr. Walker. You appear here today, Mr. Walker, without the benefit of counsel. Is that how you want to proceed?
I wasn't really given much of a choice. They said I make.
Your audio is not very good, Mr. Walker, so I'm going to ask you to repeat yourself. I think what you said was you didn't think you had much choice because they said you made too much money. Is that what you're claiming?
Correct.
So when you're talking about did you interview with either Gary Gilo or one of the appointed attorneys and they interviewed you to determine if you were indigent? Is that what you're talking about?
Yes.
And who did you talk to specifically? Do you remember?
Gary Gilo, via Zoom.
And when did that happen?
right after I was arrested and released on bond. Or no, I was actually in jail in Otsego County, and they had me talk to him via Zoom there to see if I
do you have a general recollection of how long ago that was?
the beginning of September.
All right. And does that sound accurate, Ms. Beta, at least from your file notes in terms of when an initial arraignment may have been done?
Yes, Your Honor.
And so it looks like you had a bond set and you have since posted that bond. Is that correct, Mr. Walker? Or is it I'm sorry, is it personal recognizance bond that Judge Hessling said? Is that right? Mr. Walker, are you able to hear what I'm asking?
Yes.
All right. So, Mr. Walker, are you telling me that it's your desire to be represented by counsel?
Yes.
Is it your indication to me that you don't believe you can afford counsel?
Yes. I've actually tried to obtain counsel, and every attorney I've talked to two, and actually had to pay to sit down with them for them to tell me what the retainer was and, you know, to give me the initial speaking to, and then found out the retainers were just way too far out of the realm of me being able to pay for one.
The court finds it appropriate to refer this matter back to the Michigan Indigent Defense Commission, and I'm going to make a specific order in that regard, ordering the MIDC to re-interview you to determine whether or not you're indigent. And then you have a right to make an appeal of whatever determination is made. If you accept their determination, for example, if they appoint counsel, you may choose not to. And if they don't appoint counsel, you have a right to then appeal to the court to ask me to reconsider, in which case I will. But the process is everything goes through the MIDC first, the Michigan Indigent Defense Commission. And then after that, if you file a request to appeal their determination because you didn't like what they determined, I can determine it on my own. But those are the steps that we have to go through currently. Do you have any questions about that process?
No, sir.
So I'm going to issue that order to re-refer to MIDC. I don't know whether that will be Mr. Gilo or a different attorney, but I will have that matter handled. Mr. Dick, do you know who the attorneys are that are typically doing those screenings right now?
It is, I believe it is Mr. Gilo, and I think Mr. Brown is also handling that.
Okay, and so I'll make that re-referral. Mr. Walker, you have the ability to represent yourself, but I would have to first find that your request was unequivocal, and then there's several other things that I have to go through. Ms. Speed, on behalf of the Attorney General's office, did you wish to weigh in on the court's suggested course of action so far?
I would agree with that, Your Honor.
All right. And so, Mr. Walker, I'll create that order. I'll get that out today, and I'll send that both to the MIDC, a copy to Ms. Beta, and a copy to you so that you each have a copy of it. I'm going to set a follow-up status conference in about 30 days. That will give you time to meet with the MIDC to get interviewed and then decide whether or not you accept their decision or you do not accept it, in which case you ask me in writing for an appeal of that decision. Do you have any questions?
No, sir. I would like to bring up, in this instance, I have since started working a new job so that they can take it directly out of my paycheck. This whole scenario.
I'll stop you for a second because you need to understand that you have a right to remain silent. You have a right to be heard as well. But the reason you have a right to remain silent is because anything you say on the record could be used against you. If you're going to start talking about your employment and your payments to the state or through the county, because this is a child support non-payment allegation, those statements could be tended to be used against you. So my suggestion to you is don't speak on the open court record about those things. If and when you're appointed an attorney, you can talk with your attorney about those things, or if you hire an attorney, you can talk to an attorney about those things. But it's likely not in your to talk about them on the record.
I understand what you're saying. They've just made it to where I can't contact a friend of the court, so I can't send them the information for my income withholding so they can take it out of my check. That's all I was getting at.
Who made it so that you couldn't talk with friend of the court?
Well, they actually 2 or 3 years ago filed a restraining order, I guess. Again, I didn't know.
Restraining on the way that you were acting towards friend of the court caseworkers?
There was one in particular who took over my case. who me and him had a altercation with over the phone, and he said some colorful things to me and I to him, and that's what resulted in this. They actually made it to where I can't contact anyone at Otsego County. They blocked my number right through their switchboard, and I couldn't even call the sheriff's department or anyone.
Let me make some things clear to you, Mr. Walker. If there's an order in place that was signed by me or by Judge Mertz or by any other family court judge in Otsego County, it's because we, one of us, found that there was adequate cause to issue the order. And if I issued the order, or if any other judge did, it would have explained clearly the basis and the ways that you would be able to communicate. Because in no circumstance would there be a significant impact on your ability to functionally communicate at all. There may have been, however, limitations, because I have found it appropriate in my own cases at times to issue orders where you couldn't or other people couldn't have physical communication with a friend of the court office worker, but I've also permitted it email. And so whatever that specific order is, you're going to need to do one of two things. One, follow it, or two, within the context of that case, file a motion to change or modify it. Until you do, the terms of that order control. Again, I don't know if that was my order or a different judge's order, but it matters not. The order is in effect until you seek to change it. So seek to change it if you have a problem with the order. That's the extent of the discussion I'm going to have about it today. You have a right to be referred to the MIDC, and that's what I'm doing. We're not going to have any further hearing on this matter today until I determine if you're qualified for counsel. Then we can have further discussions through an attorney if you're represented by one. The court will be in recess today. I'll create that order and get it out to everyone as I've indicated. Thank you.
Thank you, Judge.
What did you do, sir, that you got a restraining order from friend of the court? They deal with some pretty nasty, toxic people on the daily, and they've got pretty thick skin. So for you to have gotten a restraining order put against you by the friend of the court, a no contact order via phone or in person, at least, because it sounds like the judge is saying that you would have still been allowed email contact. I guess that would give you the ability to, read things and delete inappropriate things before sending the message, unlike the brain to mouth action that you have.
Right, this is CCL 22-17790. In the interest of the Stubblefield children, and let me ask everyone who expects to testify, please raise your right hand. Do you and each of you solemnly swear or affirm testimony you shall give in the cause now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, and did we lose Mr. Butler?
I'm right here.
No, I'm sorry. Mr. Stubblefield. I thought we had Mr. Stubblefield. Oh, there he is. Okay. All right. I'm going to ask you to unmute Mr. Stubblefield. And Mr. Morrison.
Yes, Judge. This is a motion to enforce a child support obligation. It is a first appearance for Mr. Stubblefield.
Very well.
So I would ask that he be warned of his rights, I guess, before we proceed.
Mr. Stubblefield, can you please unmute?
Yes, sir.
There you go. Great. Mr. Stubblefield, I want to tell you that, as I understand it, what the Attorney General is asking is that your child support obligation be enforced.
Yes, sir.
And what that means is that they're asking that you be found in contempt for each time you didn't pay your child support. And you could, if I find you in contempt, you could be sentenced up to 6 months in jail, in the county jail, on each count of contempt. Because jail is a possibility for you in this case, you have the right to be represented by an attorney. You have the right to remain silent. Anything that you say will be used against you as evidence in this proceeding. Do you understand what I've told you?
Yes, sir.
Okay, and are you going to get a lawyer to represent you?
Um, right now I can't afford a lawyer because I'm unemployed but self-employed. I'm trying to get it where I can start making the payment. Yeah, I put on child support when the COVID hit, and they got me a visitation for my girls only 2 hours on a Saturday, and I haven't seen them in a while. But I coached one of them in t-ball, and I'm trying to work it out with the mom now if we could work it out, so we won't have to go to this point.
Mr. Morrison?
Yes, I mean, I'm glad to go ahead and proceed if he wants to proceed. I'm glad to talk with him about a proposal also as well.
Yes,
It would be a probation is what I'd be asking, in which he's ordered to pay his support, and we would put an extra amount on the amount that's owed,
Yes, sir.
and he would be ordered to do that or be subject to a revocation. But that's what I would offer him if he'd like to do that or if he'd like to proceed. I don't know if either way.
Can I ask you a question? Because I got child support. I got 8 kids, 6 other kids outside of the 2. I had one homeless in St. Louis trying to go out there to find work because I was on probation. I got off probation, and I actually was on probation for 10 years. I finally got off of that.
Sir, Elon Musk has like 12 kids, I think, 13. But here's the difference. He can afford them. You have 8 kids. And you're unemployed but self-employed. And this is just wild. I don't understand this mentality.
I got all that paid up full, and it's kind of hard for me to balance. If I can work out something with the balance, with the payment, basically.
Judge, I don't know if the court would like me to go into a breakout room with him or just I'll go ahead and proceed. Either way is fine.
That, let's see what kind of time we're looking at here. Okay.
That's why I was trying to get it worked out with her because it's kind of hard with 8 kids to try to. I got one that's getting like 4 a month, and I'm working on that. We working, me and the mom.
Mr. Morrison, I see that we finally have Mr. Miller on the call,
Okay.
so we can go back to that.
Yes.
And Ms. Butler and Mr. Stubblefield will come back to you in just a little bit. We'll go back to the Stubblefield matter. And Mr. Stubblefield, I'm not clear on what you want to do today.
I was trying to see, can I get, like, if I can start making $100 payment a month to start out, because I'm not on a regular job. I've been trying to apply, but I walked on 10-year paper, and I'm just trying to get it adjusted so I can start making payments.
Mr. Morrison?
I'd be glad to talk with the parties. I think in this case, I probably would be offering a probation because of the payment history is very lacking.
Yes, sir.
In this case. And that's what I would be offering would be a probation with a payout on that. But I would be offering a 10-year probation with the conditions I would propose would be to pay the current child support, also pay at least another $100 a month on back child support and another, let's just say $25 on the back medical support. That's what I'd be asking. That it's because the past pay record is so deplete of anything, that I feel like I would need to take that step, or at least ask the court for that step. So,
Mr. Stubblefield?
Yes, sir. I'm here.
Did you hear and understand, Mr. Morrison?
Okay. So what is the payment a month?
It'd be 246 on the child support with your rearage. And was it 25 you were asking for on the
I
medical?
think so. I think that is governmental health care, and
yeah, right.
So
that would be $60 a month on the medical support reimbursement.
So 300 a month.
I'm sorry.
So it's about 3 a month.
it'd be 306 a month total. Right.
Is there any kind of can we get that adjusted where I can pay something towards it? Because I'm supposed to be paying 3 some, 4 some on this other one.
He could always, I did not plead a modification, Judge. I think that's probably what he's asking for. The child support is very low.
It is very low.
Right now. He could always apply for our service. I mean, apply for a mod and review from our office, and we'll look at it based on the number of children he has. But it is, I mean, it's $146 a month right now. So I don't know if it would go down too much, and the court may not even want to lower it more than that. So I don't have a modification pled at this point in time. So
sure. So, Mr. Stubblefield, what do you want to do?
Yes, sir.
What would you like to do today?
Is there any kind of way I can just start paying 140, trying to make the 140 and get it to him? Just some kind of payment?
Well, that's what we've been waiting for 4 years.
Yes, sir. I know I've been on probation and I've been taking care of business, and I went out of town trying to find a job. I was on probation for assault caused by the injury. And I tried to go work for someone and he ended up getting killed.
You were on probation for assault causing bodily injury, and then you went to work for someone and he ended up getting killed? Quite the crowd you're running, buddy.
In St. Louis, so yeah, I kind of got in a bind with that. So.
Well, respond to what Mr. Morrison is asking. What he's asking is that you be put on probation for 10 years, conditioned on your paying your child support and your medical support. And if you don't, you'd be exposed to the possibility of having that revoked and you being sent to county jail.
Yes, sir. Okay.
What Mr. Morrison is doing
Yes.
is offering that instead of asking that you go to jail today.
Yes, sir. Well, can I take it, like, if I can get like 140 or whatever, as long as I'm paying towards it, is it good?
I can address that with him, Judge.
Sure, go ahead.
I'll be glad to go to a breakout room if he needs it. But, sir, I think the order would be the court's order, and you would be subject to, I'm just going to say, getting in trouble if you did not pay the total amount. Obviously, all monies are helpful to the household and are appreciated. But as far as the court order, you could expose yourself to liability if you did not pay the total amount each month.
At the rate he's going, he can expose himself to a whole lot more than that. I mean, come on, guys. There's some things that antibiotics just can't cure.
Could happen. And I guess if that's the best way to explain that.
Is there any kind of way I can speak to the other party and try to work it out? See if we can work it out.
Judge, I don't mind going to a breakout room if the parties are okay to do that, but
Okay.
I don't want to delay things either. If Miss Butler's
Well, that's
fine with
fine.
that.
Ms. Butler, do you have a response to that request?
No.
Okay. All right, I'll try to set up another
Okay.
breakout room.
Thank you. I'm sorry, Judge.
That's okay, no problem. Okay, Mr. Morrison. And I'm going to ask you to unmute. There you go.
There you go. I do think we have an agreement, but I believe Mr. Stubblefield hasn't made it back yet. So let me see if I can have somebody check on him.
Okay. All right, Mr. Stubblefield, he's back. I'm going to ask him to unmute.
Hello?
Yes, Mr. Stubblefield, can you
Hello?
re-engage? Yeah, can you engage your video capability, please?
Can't hear you. Hello? Hello?
You on here, Roy?
I can barely hear you.
He keeps muting himself. He was driving earlier before we had the hearing. And if he's doing that, that's going to affect his connection.
He keeps muting himself. Driving earlier. He wouldn't be trying to deceive Your Honor.
I'm here.
Can you
Hello?
engage your video capability, Mr. Stubblefield?
I'm here.
Yes, sir. Can you engage your video capability?
Let me see. Start my video.
Okay, there you go. All right, Mr. Morrison, we're back on the record in CCL 2217790 in the Stubblefield matter.
Yes, Judge, we do have a proposal. I think all parties, I would be asking for the court to find Mr. Stubblefield in contempt, that he be ordered in addition, be sentenced to 180 days in jail, but be probated and be suspended, be placed on probation for 10 years. Basically, we would ask for a judgment on child support of $7,738 and a medical support judgment of $1,440, and of course the cents attached to those. We would be asking for an $85 payout on child support per month and a $15 payment on the medical support a month, which would place Mr. In essence, his obligation, minimum obligation would be the $281 a month that he would need to pay. That's what I'm proposing in this case. That's hopefully agreeable to the court, but I believe the parties are agreeable.
Sure. Ms. Butler, is that your agreement?
Yes, sir.
Okay, and Mr. Stubblefield, is that
Yes,
your
sir.
agreement as well? All right, I find
Yes,
the
sir.
court has jurisdiction. I'll find one count of contempt as alleged in the motion. Based on that, I'll sentence Mr. Stubblefield to 180 days in the county jail. I'll suspend that and place him on probation for the term agreed to. Find a child support arrearage of $7,738. Enter judgment for that amount and order that paid at $85 per month. Find a medical support reimbursement arrearage of $1,440. I'll enter judgment for that amount and order that paid at $15 per month. And I'll sign the order when it's submitted.
Can I ask another question, Your Honor?
Sure, go ahead.
What about the visitation thing? They got it for 2 hours on the first and the third and fifth weekend. I haven't seen my girls in a long time. I just got them for a couple of hours the other day. She let me get them. I mean, they've been gone for 4 years. Like I said, I had to coach T-ball for an hour, and that was the only time I got my family.
And
Like 30-something kids, grandbabies.
yeah,
And like I said, I was on put on child support during COVID.
Mr. Morrison, is there a motion for reconsideration of the access of the dad's access?
There is not right now.
Okay.
We just filed, the only thing we filed was to enforce child support.
Okay, Mr. Morrison, I can't tell you how to do it because the rules that govern my conduct don't allow me to give you legal advice or to assist you in any way, but I have to tell you that I can't take any action unless you file something, give
Yes, sir.
Ms. Butler notice of what you filed, and then present that to the court and request a setting on that. I'll be
Okay.
happy to give you a setting if you will file a motion to modify that.
Okay.
Okay?
Yes, sir. Because like I said, I haven't spent no time with them at all. My girls are begging. I mean, last time I took them home, they were like they didn't want to go there. They not in a bad way. It's just that we haven't spent time together.
Can I say something?
Yes, ma'am.
He can see his kids. He ain't trying to see them.
Okay.
That's what it
Well,
is.
again,
That's the
that's
problem right there.
all right.
I'm not because I'm not stopping him seeing his kids. He
Sure.
ain't trying to. So
Okay, well, again, the matter of the dad's access is not before the court today. You guys can agree to whatever you think is in your children's best interest. But for the court to get involved in making a decision about that, there has to be something filed that raises the issue in a way I'm allowed to pay attention to.
Yes, sir. And I get everything together. We'll communicate on the visitation stuff, and
Okay.
I'll work it out with on that and get this stuff caught up.
Okay. Good luck to you folks. You're welcome to stay or go as you choose.
Yes, sir.
That was a whole lot of fun, you guys. What the hell are you, Palmy in disguise? He would so appreciate that. I sure had fun. All right, guys. I need to get some rest because I don't know what time my mother-daughter event is starting tomorrow. And I just know that half of my morning is going to be spent getting that wheelchair loaded up into the van by myself. Good times, good times. No, I put it in the window. I put it in the window like upside down on its lid thing. So I'm gonna let it kind of just like gravity do its thing. And yeah, then I'll just buy a new bottle. You know, the smart thing. Nobody ever accused me of being smart. Smart thing would be to just cut this bottle open and use a spatula and scoop it all out and put it into a Tupperware and then set it on my desk and forget about the Tupperware being there and never touch it again. And just a waste of time that way. No. She can't. It's she she's got her own medical issues. So it's not something she's able to do. And even though it's hard for me, I have tricks. You know, I've got 43 years of adapting to circumstances. So I have tricks to be able to accomplish things that other people would just believe aren't doable. Thank you so much for being here. Oh yeah, you want those digits. All right. You got my digits. I will. We haven't had a mommy daughter day for a long time. It's been probably a year, maybe a little more than a year since we've had an actual like big city day. Yes, I hope so. I might just end up doing body cams tomorrow because I won't have time to edit cases and stuff, but depending on what time we get back, that's gonna be the determining factor of whether I come on or not. But the boys have been sending me body cam videos left and right. I've got them from Manuel and Jerry and Joey and I think Auntie M might have sent me one too. Yeah, like body cam vids. Like I'll take them. But I don't do body cam streams as often as court streams. But the best way to know if I'm coming on or not, because I do sometimes stream during the day. It's definitely more rare. But it happens. And so the best way to get all of the notifications, obviously, like, subscribe, click that bell notification, all that BS. But join the Discord. Links are in the description for everything in the link tree. So join the Discord. I will. I'll give Earl special cuddles and kisses from you, Patrick B. I was just looking for him, but I don't know where he took a crap and then laid down. So too much work. And gravity will do its thing without my intervention. I put the lotion on the skin. Or I get the hose again. All right, guys, I love you so much. Be safe, be well, sleep sweet, and much love.